Judgment in the appeal, Birch and Birch.
The judgment of the court will be explained by Lord Wilson.
This appeal raises another conundrum in relation to the making of financial orders following divorce, but this time under the law of England and Wales. Where the divorcing parties have property, the order will usually adjust the proportions in which they should each hold it. Subject, of course, to any right of appeal, that sort of order is once and for all. Section 31 of the Matrimonial Causes Act 1973 makes clear that neither of the parties can ask for a property adjustment order to be varied, even if circumstances change. But sometimes the order will include a provision that an item of their property, often the matrimonial home, should be sold, for example, on a specified date. That sort of order is one that, under Section 31, can be varied if circumstances change. The conundrum is, what should the court do about an application to vary an order for sale of property in the light of its connection with an order for property adjustment, which is not itself variable? In the present case, there was no actual order for sale of property. Instead, the wife gave an undertaking to the court to cooperate in a sale, but it comes to the same thing. Her application, which is for release from her undertaking to sell, must be determined by reference to the principles apt to an application for variation of an order for sale. In July 2010, the wife was living in the home near High Wycombe with the children, then aged 10 and 8. The home was jointly owned by her and the husband who had left it, but it was subject to a heavy mortgage. The order then made, which was by consent, and on the basis that the wife would never seek continuing payments of maintenance from him, was that the husband would transfer to the wife his share of the equity in the home, but subject to the mortgage, for which she was to become solely responsible. Then came the undertaking. It was that, unless by 2012 she had managed to secure the husband's discharge by the mortgage company from his liability under the mortgage, she would then cooperate in a sale of the home, which would, of course, have that same result. In 2011, the wife applied to the court to be released from her undertaking to cooperate in a sale of the home in 2012. She said that her various plans to persuade the mortgage company to discharge the husband from liability had not materialized. She asked for release upon her giving another undertaking instead, namely that she would cooperate in a sale of the home in 2019, after the younger child would have completed his A-levels. On any view, it was ambitious for the wife to ask for postponement of sale of the home for 7 years. The trouble is that after 5 of those years, her application has still not been heard. It has become bogged down in a submission by the husband that the court did not even have jurisdiction to hear it. And relying on a decision of the Court of Appeal in 1996 called O'Melan against O'Melan, he has argued that the wife is in reality seeking to reopen the capital settlement and that the court therefore lacks jurisdiction to hear it. 3 lower courts have followed the O'Melan decision and accepted this submission. By a majority of 4-1, this court allows the wife's appeal. All 5 of us agree that the decision in the O'Melan case was wrong and that there is jurisdiction to hear the application. We conclude that a court always has jurisdiction to hear an application for release from an undertaking, even though it is hard to conceive that it would succeed in the absence of a significant change of circumstances. Our conclusion is fortified in the present case by the equivalence of the wife's undertaking to an order for sale, which the court has express jurisdiction to vary under Section 31. So, should the wife's application now at last be remitted for hearing? It is here that the disagreement arises. Lord Hughes says no, on the basis that the application is bound to fail. The rest of us do not agree with him, for the relevant circumstances have never been ventilated. Apart from the welfare of the children, which Section 31 identifies as the first consideration, the circumstances surely include the alleged change in the wife's ability to secure the husband's release from the mortgage by 2012, or indeed since then, and the amount of prejudice suffered by the husband in remaining liable under it. It is not the more usual situation in which he stands to receive part of the proceeds of sale, nor has he been called upon to make any payment in respect of the mortgage since the consent order was made. The prejudice presumably exists in the effect of his continuing liability under it upon his ability to obtain another mortgage on other property for his own purposes. And this will need careful study at the hearing which today this court directs to be conducted as a matter of urgency.